Welcome to the Home and Finance Show. I'm Diana Rice-Wilkerson, lender with Fairway Independent Mortgage, and joining me is my co-host.
Hi, my name is Janis Bradley, broker-owner of JB Real Estate Consultants.
We are your seasoned, trusted advisors committed to personally navigating you through the home buying and home lending process. The show is designed to provide you with current and relevant information about different aspects of home buying, home selling, and lending so that you're knowledgeable when making decisions for you and your family. You can also hear us on Saturdays on Radio 1, 1310 AM, 92.7 and 95.1 FM. That said, if you're in the market to buy, build, or refinance, we'd love to represent you. You may reach us at the contact information below. Now on with the show. Hello, Miss Janis Bradley.
Hello today. Hello today. I was almost going to say good morning, but I think it's afternoon. Lovely afternoon.
We'll take it.
Yes. Okay. And Diana, are you excited about our guest today?
We are both elated about our guest today because, you know, she's all that and a bag of triple chips.
Triple.
So welcome back, Jennifer Norton.
Thank you. Thank you.
It is always so exciting to have you on our shows as a guest. You are just superior. And the kind of information that you give out, we are just so blessed to be able to have you because we know you got it going on. So first of all, please introduce yourself, and after that, share with everyone what exactly is an estate planner.
Okay. So I'm Jennifer Norton, as they mentioned. I practice in estate planning at Norton Estate Planning and Elder Law Firm at 3750 North Meridian, so just north of downtown. I help prepare clients' wills, their trusts, their powers of attorney, life insurance, trusts if we need those types of trusts. I help with powers of attorney, I think I said living wills. We help with strategic Medicaid qualification, probates, and guardianship assistance if people need to get qualified for guardianship.
And what about the elder law part?
So the elder law part, typically that is the part that deals with the Medicaid.
Okay.
But a lot of older generations will call me an elder law attorney. The newer generation will call me an estate planning attorney. They actually do the same thing.
Okay.
So it's all about any type of legal documentation when it comes to your estate planning documents. So wills, trusts, powers of attorney. Elder law, you know, estate planning attorney. Now, there are some attorneys that say, when they say elder law, they mean they only deal with Medicaid.
Okay.
But that's why it says Norton Estate Planning and elder law. So we're going to capture both
That's the whole
sides.
thing.
Call me what you will. I'm going to be there.
Outstanding, outstanding.
Well, we know that you are a wealth of knowledge, but we have a few questions for you, and we'd like you to talk about it, share about it. We don't have a whole lot of time, but I know how excited you get. So, Diana, you want to ask the first question?
I'm all about it.
Okay, go ahead.
It's the quit claim deed.
Okay.
Because we are running into all kinds of situations, even on the mortgage side, where people have been quit claimed onto a deed. I've had borrowers, especially mom, dads, older people, who have forgotten that they added maybe kids, and now the kids live in other states or possibly can't even be found. And now they're trying to refinance, or you know what I'm saying? Or, you know, so, that's just one story. So talk about that. And I think because people can actually complete that form, take it down to the recorder's office and have it recorded, they think that's all it is to it. Only to find out later they should have had an attorney involved. So will you please talk about the quit claim deed?
So this is,
So and it says do's and don'ts. Our questions are do's and don'ts.
Okay.
Go
I'll start with the basics. So a quit claim deed essentially is a deed that says I'm going to quit claim all my right, title, and interest in a property to whomever I'm, agreeing to. But the catch is, if you have no rights, titles, and interests, you quit claim nothing, okay? So it doesn't guarantee that what you're giving to someone you actually own. It says, well, what I think I own, I'm giving you what I think I own. You run into the issue where, yes, people can go downtown, they have the forms, and they can just sign up themselves and quit claim their interest, whatever that is, to a person. But then what happens is, like you guys are finding out, people forget. And so if whoever you put on that quit claim quitclaim deed, in order to transfer it, they need to be present to allow for that refinance, that sell, whatever they want to give it to someone. They would need to be on board and in agreement with that, or else you may have run into these issues where people need to buy people out in order to, take their name off the deed. And then the last piece about this with the quitclaim deed, which you run into, is when a death occurs.
Yes.
People assume that because I put someone's name on the deed, when I die, they're going to own it. And not in Indiana. In Indiana, they assume that the people are what they call tenants in common, which means they each own, say it's two people, 50%. So when the one person dies, their 50% will go to their beneficiaries, not to the co-owner. And so when you do quitclaim deeds in Indiana, if you want it to go to that other owner, you have to put jointly with rights of survivorship in order for it to go. Now, if you're purchasing it and you're married, or you're receiving it and you're married, the law assumes what they call tenancy by the entirety, which means each spouse owns the entire house. So when one person dies, the other spouse is left owning the entire house.
I love it. And the other thing you can't do, and you said it, but I just want to say it in a way that I know you'll get it. Once you add a person's name through the quitclaim deed process, even though you were able to do that, you can't just remove it. Because some people think
because you got mad.
I gave it to you, now I can take it back. No, you can't. You just brought somebody else into the ownership of your property, and as Jennifer explained so eloquently, now you need them to sign off on anything that you decide to do, sell, refinance, or whatever.
Yes.
Would you also speak about the fact that when a person is also added through that process, if the current owner has liens and judgments against the property?
Yeah. Okay.
Yes. Let's speak about that.
We have clearly a situation going on.
That situation.
Yes.
Actually, I have too.
Yeah. So the problem with liens, any type of encumbrance, like taxes or child support, if you have those types of judgment on your person, or the person you're thinking about getting or joining ownership with, it all attaches to the property when you're trying to sell if they haven't resolved it. And no, they don't say, oh, I'm going to reduce your 50% by your judgments. They attach it to the entire property, but then give the proceeds still 50%. So it can, one, reduce the amount that you're going to receive because the title company doesn't care. They just want to give clear title, and the law requires them to clear up all judgments, credit card debt maybe that you've avoided paying. And then two, it can impede a sale, because if someone says, yes, I ain't paying that, or if one person says, I don't want your debts, then we can't go through with the sale, because one person says, I want full value, but the parties would all have to agree. So liens and encumbrances and stuff like that, like divorces and child support, those literally will attach to the property, and you have to come to some type of agreement in order to get the property sold. Else we're stuck. We're going to keep owning this property together, unhappily.
So this is what I need for you to say about the don'ts.
Okay.
Okay. So don't add me, or don't quitclaim it to me without an attorney. And can we say why? Okay, because let's say, because what I have a case now is that you quitclaimed it to me, and then I quitclaimed it to you. Okay?
Okay.
All righty. Nope, and that's it.
Oh.
Okay? And now you want to sell the house.
Okay.
But we've got some issues here.
Okay.
Okay.
That now I have, because they passed through the real estate.
Exactly.
Okay.
Without what? An attorney.
An attorney, yeah. And so a lot of times what you want to do is just make sure that when you're doing these quitclaim deeds, I would think that you would even want to involve a title company.
Absolutely.
Because the attorneys really don't do the searches. The title companies would be able to do the search. So even if you're just, it's my neighbor and we're gonna sell the property between, or family members, it's like, okay, we're gonna at least at a minimum involve a title company, because the title company will make sure that the debts and stuff are removed, because even if you quitclaimed it to each other, the liens are still on the property you just gave to her, even though you gave her the property, the liens are still with it. And even though they're not hers, she has to go through the process of getting you to say, yeah, those aren't hers. They're really mine. What person really wants to say, those aren't really hers, and they're really mine, you know? So that becomes an issue too of whether or not you're going to be willing later, or if you're even alive or in your right mind to be able to say, yes, that's my debt. Bring it back to me so she can go sell her property. So we typically don't, when you're in those situations, you would want to, one, contact the attorneys to make sure you're drafting the right type of deed. But if you can even get a title company that has the ability to do the search for you, then that would help too.
That's good.
That's good.
That's
that
good.
is
Very
excellent.
good. Yes.
Because most of the time it just says, people say, well, you have an attorney do it. Yeah, so then basically you're just doing the paperwork, not the searches.
Not the search.
Yeah, you know, that's good.
Unless it's a law firm with a title company, which there are those out there, that you can get both.
Yeah, I am aware of that. That makes sense. I like that. I like that.
Yes.
What is our second question? I think this is a question that you had.
It's about trust.
Yes.
Okay.
So we're hearing a lot about trust.
Okay.
And so can you just break it down in like simple terms, what it is, who should be looking into it, when it's a good time to look into it? Okay,
so a trust is nothing but a set of instructions. It tells your property where to go. So the state has default provisions, and if you recall from my prior episodes, and if they haven't seen them, they can go back and watch your prior ones. But essentially, when a death occurs in the state of Indiana, the default is that even if you're married, half goes to the spouse, half goes to the children. If you're unmarried and have children, it goes all to your children. And so if you don't like the default, you go get a will, which does go through probate because it tells the court, the judge, I don't like the default.
Okay.
Or you can get a trust that's, again, telling the world, I don't like the default. Trust, however, can avoid probate, not will. I'm still an attorney. They can, but you have to retitle all of your assets today into the name of that trust. So if I buy a house, remember, you still want to put the deed in the name of the trust. The loan, of course, is going to be still attached to the property. They're two separate transactions, but you still want to put the deed in the name of the trust. Your bank accounts, your investment accounts, you want the beneficiaries on life insurance and retirement plans. You want all of that to reflect the name of your trust so that the instructions in this document can control those assets to say, don't follow the default, right? I want these rules to control. But you have to put everything in there, because if you forget something out, remember, you still get a will when you do a trust. It's known as a pour-over will. It says, if I forget something out, go get it. I left it out there with no beneficiary, no joint ownership. Go get it and pour it over to my trust where all my instructions are.
Okay.
But all wills go through probate, so you don't want to leave it out. Right? When you get a trust, the goal is you want to retitle everything today. And a lot of attorneys will only do the deed, because they'll say, you can't do the deed without me. But they'll give you instructions to go do the rest, which we know most people are not going to go do all of that. Or they'll do some of it and not all of it because they get tired or they get frustrated. When should you get a trust?
Yes.
Now, I always say it depends on your goals. It's not about wealth, right? You can have 100,000-aires that have trust and millionaires that have wills. The reason being is they're looking at the beneficiary, right? Am I concerned? Do I not like their spouse? Do they not know how to manage money, the beneficiary and the spouse? Do I want to protect it and dole it out in stages? Because a will just give it all to the beneficiary and then they can go do what they want. So if I'm concerned that they're going to splurge and not use it appropriate, then maybe I want to trust to kind of dial back the terms. Am I concerned about, we've had clients that have been concerned about divorce, and they have, their children love. And so they love, and sometimes they end up in divorces because they love the wrong person. So maybe they want their children to have prenups. Maybe someone's special needs, right? So we don't want this inheritance to disqualify them from getting governmental benefits they'd otherwise qualify for. What other reason? Maybe we want to just preserve the money for another generation. You have to leave assets in trust to make sure it gets that next generation.
That's right.
Most people blow through it in the first, 70% of the assets are blown in the first generation. And so when you're thinking about a trust-based plan, think about it as a controlled transfer of the inheritance. That's when you would want to do a trust. Versus a will, you're saying, here it is.
I love the term controlled transfer.
Yes.
That's and I can see with grandkids, especially how grandparents are with grandkids, and you know your grandkids are still young.
Right.
Yes.
But you want to have provisions out there maybe for them at different stages as they become adults.
And that's why the law says we already default minor children with trust.
Yeah,
Because they need a controlled transfer. Now, that problem is they end their control at 18, right?
Yes.
Now, whether or not they're truly capable of controlling the money at that age.
It's a scary thought.
Yeah, a very scary thought, right? So what you want to do is if you do a trust, don't fall for the standard form terms that most attorneys are giving you and push them to push those ages, that 18, further, right? Maybe you want 30 because they say the male brain isn't mature until 25. So maybe you want to say, okay, I'll for my...
Are you sure about that? Okay, I didn't. Okay.
She said, no,
that's right. I thought that's what you said. Okay.
So maybe you push that one a little further, or you find your child, like my son is a lover. He loves pleasing women and making sure you're okay. Okay, son, we got to control that transfer. We got to tighten that up a lot. Because women will come in, Tide, I need this. And he's going to be like, okay. No. So he is a person that is ripe for a trust. Now, as he gets older, he may mature, get a little tougher, thicker skin. Then again, a trust will allow you to keep tweaking those provisions versus the will just says, you're done.
And when you set up a trust, if you're the one setting it up, that means you can change.
Yes, absolutely. Okay. A revocable living trust, you can change.
Revocable, but an irrevocable trust.
An irrevocable trust just means a revocable trust always becomes irrevocable when a death occurs.
Okay,
because your terms are locked in some.
Got it.
Though it could be a flexible term. So it doesn't mean that the plan can't change. It just means your last words are locked in with the death. When we're thinking about Medicaid, right? If someone is facing a health situation and they need more financial assistance and want to move into either assisted living or traditional nursing home care, we got 24-hour care, or there is in Indiana Medicaid waiver, you want in-home assistance, then one of the strategies is that someone in the family can set up an irrevocable trust today to hold your assets. So we're trying to get them away from you, which means you can't control it. So think about if a revocable trust becomes irrevocable at a death, they're away from you. You died, right? So you can't control the assets.
Right.
So basically, when you're doing Medicaid, you're fast forwarding, you're bringing that after death provision to the forefront while you're alive. You can't run the money because if you had died, you wouldn't be running the money.
Right.
It's not in your name. If you had died, it wouldn't have been in your name under your Social Security number. So when you do an irrevocable trust, someone's running it. It's not in your name and it's not under your Social Security number. It has its own EIN.
Wow.
The same concepts would be there if you had died.
Gotcha.
And so you can't. So some people say, "Oh, I'm just going to set up irrevocable trust, put my money in it, and I'm going to run it."
No, you can't.
You can't because remember, in a revocable situation, you would have died.
That's right.
So you can't run it. So it's the same kind of principles, but you do set up irrevocable trust, I would say, if you see an illness, like if you can foresee it being long and drawn out and you don't want to spend it, you could set up an irrevocable trust. If you have a very large estate and you're like, I want to get some of my money out of my estate right now so that when a death occurs, the federal government can't levy a tax on me transferring it to my beneficiaries. So right now, the federal government says if you have an estate, as long as it doesn't exceed $12.9 million, which a lot of people in this country do not have $12.9 million, then you don't owe us a tax. But that's supposed to sunset in 2025 back to $5.49 million. So that could affect a lot of people.
That's right.
And so some people will say, wow, while it's up high right now, let me move some out now. Let me we call it a coupon. Let's use some of my coupon while I'm living. I'm gonna put it in an irrevocable trust now so that when a death occurs, I can, be under. The goal is to be under.
Right. I've got some questions. Do you have a question?
Yes.
Go ahead.
I do. Does that mean everybody needs to have a trust?
No. Great question.
Thank you.
Everybody does not need a trust. Again, it's all goal-oriented. So if you think your children are doing well financially, they're good stewards. Some of my clients are like, my children make more money than me. They make better decisions than me. By all means, you don't have to have a trust. You can just say, I'm going to put beneficiaries on everything so that it can completely avoid probate and get to my children quickly. And that way, I know they're going to do well with the money. So I don't need to spend all that money getting the trust. So no, everyone does not need a trust. It's all about your concerns. So I create documents that solve problems or provide solutions. If you don't have a problem with those people, then we don't need it.
I like that. I like that.
Now can I ask my question?
You can.
All right. I want to talk a little bit about probate and wills and things of that nature. Okay. And I want to do it this way. Okay, we're mom, dad. We have a house. We don't have a lot of other money. We have this house. It's paid for. Okay. Right? And we've got 4 kids, and we want to leave it to our 4 kids. Okay. What's the best way?
It depends.
Okay. And say that is literally the only asset.
If it's the only asset, okay, so there are multiple ways. We'll go through them. The first is you could always do a transfer on death deed, which is put the children as a beneficiary so that the minute the death of both of them or one of them, depending on how many people own it right now, it will pass them by law. Then all they have to do is file what's called a heirship affidavit after the death to say, Mom and Dad have died, we're the heirs, and only one person has to sign it. We're the heirs, and then they please transfer it into our name, and they go record it at the recorder's office. Very simple process. Okay. Transfer on death deed. Option 2, you could put their name on the deed. We talked about quick claims, right? But you would want to do your research. You know your children, hopefully. Or not, right? Because things can be under the rug. But you use a title company and then you don't have to worry about that, right? So you could put their names on there. Putting their names on the deed could help if that's, like you said, mom's only and major asset and they want to transfer it to their children, but they don't want to lose it. But if we know people are living longer but not necessarily better, so if there was a Medicaid situation, by quick claiming it and adding the children today, as long as mom or dad or whoever needs to qualify does not seek qualification within the 5 years of you doing the transfer, then we can protect the house. So a quick claiming it is an option. Okay. So sometimes my single parents will say, well, let me just go ahead and add my daughter to the deed. So I had a client literally in yesterday, and the husband died back in the early 2012, 2013 or whatever. So when dad died, the new attorney put the daughter's name on there jointly with rights of survivorship, because she did have a sibling that mom didn't necessarily want to, she wanted to leave it up to her daughter to make the decision. So it would pass to the daughter by law, but with no probate. Right. And because they did it so far, we're already in 2023, we're past Medicaid. So I said, we're not touching that deed because it's already protected. Because government and Medicaid cannot force someone to give up their rights in a piece of property. But what they can do is say, if you're intentionally trying not to pay us in these last 5 years, we can tell you give it back or keep it, but we're not. We're gonna sit on our hands and our money until that penalty period runs. So transfer on death deed, you can do a quick claim, but check them. Do your background check, do the title company. You could do a life estate deed. Okay. So a life estate deed is also a form of Medicaid protection. What a life estate deed is, you're saying, I'm gonna give mom and dad, you retain this asset during your life. But at your death, these are the beneficiaries. Now, the difference between a transfer on death and a life estate deed is a transfer on death deed means you're a beneficiary, meaning you have no rights until the death occurs. Right. With a life estate deed, your rights vest the minute the deed is recorded, meaning if I gave you guys a life estate in a piece of property and I'm the remainder beneficiary, well, if you go to try to sell that piece of property, what you're only selling it for your lives. The minute you both die, it reverts to me, and whoever that seller is got to come up off of it. Right. Okay. No matter how much they paid y'all, that's right. It's my land. Right. And so most people don't want to buy a life estate deed, but what a life estate deed does, it also can afford that Medicaid protection if it's done within prior to your 5 years of trying to apply, because again, Medicaid can't force you to give up your rights. The only downside again of a life estate deed is if you want to go sell it, you got to go at the remainder beneficiaries have to be on board because their rights vested the minute a death occurred. Right. I mean, sorry, the minute the deed was recorded. As opposed to a transfer on death deed, they have no rights until the death occurs. So that's kind of your kind of teeter in between. So sometimes if it's a married couple, I might say, well, we can do a transfer on death deed for now. Yeah. Or if it's a single person, I say, you want to do a life estate deed? You want to do let's check them out. You want to do a quick claim deed? What do you prefer? So it just depends on what the situation is.
What about a will?
Okay, so a will.
In that situation, this single house.
If you have this single house and a will, it's going to go through probate, one.
Which means what?
Which means before we can move anything, sell it, give it to someone, someone has to be appointed over the estate.
Okay.
If you didn't have a will, we look into next to kin or first to the courthouse. There is a priority. If you have a will, we're picking the person you nominated as the personal representative in that will to be the person to step up. Once they are appointed by the court, again, they can't have any felonies and they have to be over the age of 18. But once they're appointed, then we publish notice in the local paper. And it runs back-to-back weeks, 2 weeks. And then for 90 days from that first running, creditors have an opportunity to file into the estate to say, hey, before you do anything with that property, here's my claim. I'm owed this money, this debt. And then depending on, hopefully the estate has some cash, if it has to pay it or settle it. If not, then maybe we have to sell the property or the beneficiaries have to negotiate with that creditor.
Right.
But at the end of the 90 days, the judge will determine, did they properly file their claim?
Right.
And most creditors do not. They have to show evidence of the debt, swear under penalties of perjury, the debt still exists, and pay a filing fee to the court. They most often forget to pay the filing fee. So after the 90 days tolls, the judge will typically dismiss the claim because they failed to pay the filing
fee.
So we tell people, do not pay the creditor. On my way here, one of my clients, she experienced the death of a father, and I specifically told her, don't pay the creditors once we were done. She called me. We talked about it. She called me today to say, I signed some paperwork. They were threatening if I called you that they were going to sue me. What? That's your first red flag.
Yes.
If they threaten you because you're going to go talk to an attorney, something ain't right.
That's right. That's right. That's right.
So you're never liable for the debts of your parents, your loved one. The estate is. But if you leave nothing in the estate, there's nothing to claim. That's why you put beneficiaries on everything.
That's right.
Or put, set up your trust properly. So there's nothing in the estate. There's no probate to go get and have them, be reimbursed by those assets.
We need a part two.
And
part two, part
viewers,
three,
thank you so much for tuning in. And this is why we love to have Jennifer on the show.
Give your number out real quick, please.
Yes. Your number, your website.
Okay. So the website is www.estate, E-S-T-A-T-E, like an estate, -planners, plural.org. The phone number is 317-572-8696.
And again?
317-572-8696.
And her Facebook is awesome.
Yes, she follows me on all boards of social media.
She goes, I just saw Jennifer's reel. I love it.
I love it. So we hired somebody. We're going to have a reel.
I have to dial it back though. Sometimes am I too real on the reel?
Well, no, you do a fantastic job.
I learned from you guys doing your posts.
Well, I tell you what, we love you. We love you. We love what you do. We know you have a heart for the community.
Yes.
And thank you so much. And we hope to see you again soon.
Anytime. I'll come back anytime.
Okay. All right. Thank you.
Bye-bye.
Have a great day.